Hi, everybody. My name is Patty Yaffa, and I'm one of the commissioners on our town's Commission on Aging, and very happy to be here and happy that Joe asked me to moderate. So I cannot let him down, okay? And I will do my best to get everything completed that's on the agenda. It's a very good one today. Before we start anything with our guest speaker, I just want to briefly say that her name is Attorney Lynda Lee Arnold, and she is from the firm, and here I go, Sapega, okay, Sapega, Daly, Pope, and Perry in Connecticut. She's going to give us her valuable information regarding estate planning, something that I am actually looking into right now myself, so I personally am more than glad she's here. Then we're going to go into very great detail for that featured event, Estate Planning Basics is what it's titled. Then we're going to have a sounding board, and I'd like to call that, hey, what's on your mind? Tell me what questions you may have or concerns, followed by a conclusion and networking. And good. Next page, please. Okay. So news. Oh, you're good. Okay. So as a reminder to everyone who participated in our townwide survey, it has closed. It closed on December 1st. The market research company is tabulating the results, which will be available to you shortly. And I know we're all very anxious to see and learn what's on their minds, what we need to do, what we should do to better ourselves in our community. The gold card, okay, which is, I actually used mine today when I went to the UPS store. Thank you, Lisa, for putting that together and enhancing it. Please make sure to get your gold card at Town Hall and enjoy discounts throughout the town. That list of whoever's the participants, that's going to be updated in the spring as well. Something that's, I believe, close to everyone's heart. Lower taxes, please. Make sure you get your exemptions at exemption chart, which is at the back of the room, listing all the exemptions. And you can apply for many of these exemptions as early as January 1st, so just in shortly over 2 weeks. Yes, Joe?
I said, I forgot to bring the exemption chart. I'm so sorry. And if anyone wants it, and give me their email address, I will email it to you. It is available on the town's website, and then we're in the document, and they're sitting at my house.
Okay, awesome. So please take us up on that because it's very important. I know I've learned and benefited from some of those already. So now I'd like to ask Linda. Yeah, Linda, why don't you come up? And thank you again for being here. So by way of introduction, Linda is going to speak to all of you about herself, what she does, who she is. And I can say is I'm especially glad that she's here, and I hope we can all learn something from her. And her information is in the booklet that's at the back table. I see most of you have picked up a copy. And thank you very much. I need the stairs.
Me too.
Thank you. Okay.
Good afternoon, everyone. My name is Lynda Arnold. I'm an attorney with the law offices of Sapega, Daly, Pope, and Perry. I brought my colleague Jeannie Domino, an attorney that works in the firm with me today. She's in the back of the room. So a little bit about the firm, which I think is interesting. The firm is not a great big firm. People think we are. We're 13 lawyers. And the interesting part about the firm is that all of us practice exclusively in the areas of estate planning and elder law. So we focus on that area. We can't call ourselves experts, but that's our only focus. So we have a litigation department. We do will contests, sue nursing homes, all that kind of thing. Apply for Medicaid for families that have a loved one in a nursing home. Take people through the estate administration process when somebody dies. And then, of course, we do our estate planning practice, which is what we're going to talk about today. So please feel free to raise your hand and ask questions as we go through if you have any questions related to what I'm talking about. So we're going to start with the basics of an estate plan. Every estate plan should have certain things, and one of those documents is a power of attorney, a durable power of attorney. And a power of attorney allows someone to handle any and all legal and financial matters for you while you're alive, but unable to. So very important. You want to name someone that you trust implicitly. You want to have a backup or two built into the document, because just because maybe you're married and you have a spouse, that doesn't mean your spouse has legal authority to do things on your behalf. If I wanted to call my husband's life insurance company and get information, or his 401k and get a distribution or any of the like, I couldn't do that without being his power of attorney and having the financial institution know that I have the legal authority to make that call and get that information. So a power of attorney is extremely important. And we used to tell clients, update your power of attorney every 5 years, because banks and financial institutions would routinely say, this is too old, we're not taking it. So check out your powers of attorney, see how old they are. It's important that if you look at it, there's two sort of different powers of attorney that can be drafted for you. It can be a statutory short form, which has just the basic powers, allowing someone to handle real estate, bank accounts, investment accounts, retirement accounts. But that's it, the basics. In addition to those routine powers, it might be important for you to give your agent more extreme planning powers, the ability to make gifts, to transfer property, to change rights of survivorship on a deed, to change beneficiary designations. Pretty extreme powers, but they're really necessary if we have a crisis and maybe somebody's going into the nursing home. So let's say that I am my husband's power of attorney and something happens and he goes into a nursing home. Nursing homes cost $14,000 to $16,000 a month. So for most of us, we can't continue to just foot that bill without depleting our resources. So we do crisis planning, and we would apply for Medicaid for my husband.
Excuse me, Linda. Are the slides supposed to be advancing? Because they're not.
Not yet. Not yet.
Okay, but they will be. Okay.
They will be. So
All right.
I'm
Thanks.
still talking about a power of attorney, and yep, they'll advance when I move on. So if my husband needed a nursing home, we can do crisis planning. We could apply for Medicaid for him. As his power of attorney, if I have if he has a long form and I have authority to transfer assets, then I can transfer the house to myself as the well spouse. That's an exempt asset. I can transfer a car to myself as the well spouse. I can, but I need the power to be able to do that. And if the power of attorney doesn't allow me those more extreme powers, I'm not able to do that. So for most of us, a long form power of attorney would be important. And you want to pull it out, see what you have, see if you have just the basic format, see how old it is. You want to check out all those things, but it's critically important that you have that document in place. The story I tell, because it was so impactful to me, is a client who came in and she was 93 and her husband was at home and he had been diagnosed with dementia, and she thought her ducks were all in a row. They had their wills in place. She had a healthcare directive, and she had two homes, or they had two homes, and she wanted to sell her second home to free up some cash to use the money to help pay for his care. But they owned the house jointly, and he did not ever sign a power of attorney. So he can't now, because of his disease and his incapacity, he can't sign a listing agreement, a sales contract to sell the house, and she didn't have the power to do so for him because he had never authored that document. So her hands are tied. She can't sell the house. So what we would have to do then in that instance is take her to the probate court and have her husband involuntarily conserved, asking for a court order that she be given the legal authority to do these things for him because he never signed a power of attorney when he was competent and capable. And that conservator hearing is somewhat adversarial in nature. He's served paperwork to show up at a hearing. He's appointed a lawyer because the lawyer needs to make sure we're not taking away his liberties, and that he really doesn't have the capacity to do this for himself anymore. And when she heard about the process and what would have to happen, even though he really would have had no idea of what was going on, she really couldn't do that. She couldn't take that next step. So I tell that story only because it's so important that while you're alive and capable, you have a durable power of attorney created for you. You get it signed. You want to put people in those roles that you trust, and you want to have a backup or two built in. So don't wait until it's too late. And even early on, when people are diagnosed with dementia early on, it's usually not too late to sign something. They usually still have capacity to go ahead and get that done. So the biggest problem is people that don't have one and they wait until it's too late. Sorry. Any questions on powers of attorney?
Do you recommend having just one if you have more than, I have 2 daughters, so do you recommend not having both daughters on the power of attorney or one? And hopefully you pick the right.
So that's really a family decision, and it's really based on how your daughters get along, how they function. Do they get along, communicate? Because we can name 2 people and we can name them severally, which means either one of your daughters could jump in and do the work so they could help each other out. And that works really well if they get along and they communicate, so they're not working at cross purposes. If they hated each other and, didn't communicate, then I would say you would want to have one, alternately the other. So a lot depends on your family situation and how everybody works together or doesn't work together. Yes.
The third option, which I would advise against too, is to have them both be in agreement on everything. You didn't mention that as worthwhile.
So
I think that would significantly delay things.
correct. So one way to also name your 2 daughters would be to name them jointly, which mandates that they have to do everything together. They have to show up at the bank together, get on accounts together, sign all the checks, and that's really cumbersome. So and if one of your daughters is here and one lives 3 hours away, it becomes not manageable. So most times I would recommend against that, but I do have clients who say, nope, I want them to agree on everything. I want them to be involved. So I just think it's making their job harder, but everybody goes in with their eyes wide open after I've said my piece and they make their own decisions. Yes.
Are you therefore saying that if one never take 2?
No, I'm not saying take one, never 2. It depends on who your 2 are, the choices. And as I said, do they get along? Do they communicate? I feel like I could name my son and my daughter severally, and she would call up her brother and say, hey, I can't get to this today. Can you do it? And vice versa. But, would that be the case? I hope so. But if you think it's not, then I would never have 2 people. Yes.
Power of attorney is something you can do at home. You go online, you get a power of attorney certificate. My wife puts me on it, I put her on it, or is it something that has a lot of legalese to it that we need to have an attorney do it for?
So I would say you can find them online, but I would say what you're going to find online probably is the statutory short form. It has to be witnessed by 2 independent witnesses and notarized. So of course, I'm going to say I really always think you should have an attorney. Make sure you have the best power of attorney structured for you. Some families maybe they don't want those more extreme planning powers. Maybe they're a blended family and I have kids and he has kids and, you know, there's a lot of other things going on. So we have to talk about all of those things to get the right form, get it in the right format for you. The other important document everyone should have is a healthcare directive. People call them different things: healthcare proxy, directive, advanced directive, and different lawyers do them differently. We do them as one comprehensive document that contains a variety of things in the document. So the first thing it contains is a living will. You all probably have gone to your doctor and the doctor says, do you have a living will? And if you do, I want a copy of it. So the living will is really something that says, if you're in a persistent vegetative state with no hope of getting better, then you don't want to be kept alive on life support. And life support can include CPR, ventilator, defibrillator, artificial means of nutrition and hydration. So for most people, they feel that way, although we have had clients who want to be kept alive at all costs, maybe even frozen, because someday they'll come back and be ready to go. But seriously, the living will, the magic words, persistent vegetative state with no hope of getting better. It is not a do not resuscitate order. Only a doctor can order a do not resuscitate. So it's giving your healthcare representative guidance. If I'm terminal, if I have these things, I don't want any extreme measures. It goes on to name a healthcare representative, someone who's going to make healthcare decisions for you while you're alive but unable to, and a backup or two. And again, it can be two people severally, which means either or, but you want to make sure that if one of your daughters makes a decision, the other one's not saying, oh my God, how could you do that? That was a terrible choice. And you don't want to have them have some conflict afterwards. But again, you think about the players, the loved ones in your life, the people you're going to choose to be in that role and how they will best function. So healthcare directive, that role is different than a power of attorney. You know, you want your power of attorney to be financially savvy, to have some knowledge of how to get things done, not be a procrastinator. The healthcare representative, you want to make sure this person can talk to the doctor, understand the medical terminology, the diagnosis, and the potential decision-making they might have to do going forward, and that they can do it. They're emotionally going to be able to do that. Some people can't. So you want to just think about that. The document that we create goes on to name conservators. So it's usually the same order as the healthcare representative. And that's just a guide also if you later need to become conserved, you've named in advance who you'd like to be in that role. And then there's a spot for organ donation. So it's all encompassing and it outlines your wishes and who is going to be authorized to make those decisions for you. Any questions on healthcare? Yes.
Does the healthcare representative have to have proof, like paperwork in the hospital for their conversations with the doctor to prove?
So the question was, does the healthcare representative need that document in the hospital to prove they are the one that's been appointed to make those decisions? And I would say technically yes, although some doctors will give a wider latitude, or if you're conscious and awake and your daughter's with you and you say, it's okay, I want her to hear everything, I want her to know, then the doctor's going to do that. But if you were unconscious and your daughter or your loved one walked in, yeah, they should have that document just to be sure. So I tell clients to make sure after they've signed them to get one to their primary care physician and to their representative so they have it.
But should they be giving certified copies? so that it's all safe.
So with the healthcare document, we notarize them and there are 2 witnesses, but copies are as good as originals and doctors will take copies. Not quite so with the power of attorney. Banks and financial institutions want to see the originals. Any other questions? So then, basic estate planning, last wills and testaments. You've all heard of a last will and testament. I'm sure you know why it's very important. If you die here in the state of Connecticut without a will, then the state of Connecticut is going to dictate how your assets get distributed. So if you are married with children and have assets in your name alone, the first $100,000 goes to the spouse. Anything over and above that gets split between your children and your spouse. If you're married with no children, but your parents are alive and you have assets in your name alone, again, your spouse gets the first 100. Your parents would get 25%, and then your spouse would get 75% of anything over that $100,000. So really probably not the way you would have wanted your assets to be distributed. So it's important that you have a will. I have heard people say, I really don't have anything, I don't need to bother. Yes, you do. Even if you have very little, you want to be in charge of where your assets go when you die. Maybe your parent is 98 years old and shouldn't be getting an inheritance. Maybe they're already in a nursing home and on Medicaid. That would really mess things up. So you want to create a will and you determine who the beneficiaries are going to be. You also determine who the executors or executor is going to be, the person that's going to ultimately gather the assets and settle your estate when you pass away. You also determine, are there any people we need to protect in the will? Have you had a child who has addiction issues or they've been incarcerated? You might not want to give them an outright inheritance. If they've been incarcerated, the state can recover up to 1/2 of their inheritance to get paid back for their incarceration. So there are just a ton of things that we want to think about. Are the beneficiaries healthy, stable? Are you worried about divorce issues with your children? Are you worried about special needs children? All of those things. Are you worried about a spouse who might not really be able to manage things? So we can create lots of sub-trusts for these special needs people or people you want to protect, but we have to talk about it because it's not a one-size-fits-all for all of us. Everybody's situation is different. So we want to make sure we tailor your will to meet your family's specific needs and that we don't, you know, if you have a child that's on SSI and state benefits, you don't want them to get a straight inheritance. It would knock them off their benefits. So, but there are ways we can get it to them without that happening. So we want to make sure we talk about all of those things and get the document in shape so that it works for your family and their needs. So it's really, really important. When we meet with clients, we have them fill out a comprehensive questionnaire prior to coming in, and it gives us all the family information. We ask if anybody's on disability. We ask for asset information. People sometimes don't understand that. Why are you being so nosy, Linda? Why do you want to know what I have and how I'm holding it? Well, it's important because I need to assess how much do you have? Are we worried about Connecticut estate tax? This year, the Connecticut estate tax is anything over 12.9 million per person. And the same federally. But in 2025, that legislation sunsets. So it might get pulled back down to what it was in 2017, which is 5.4. So most of us are okay. We're not bumping up against that 12.9 million, but pull it down to 5, maybe there's an issue now. We want to talk about taxes. Is that an issue? Do we have to build in taxable provisions? We want to see how you hold your assets. Do you have assets with a beneficiary on every single thing, even bank accounts? but you have real estate that's going to go through probate. Are you creating a cash poor estate? Some clients put a child on one of their bank accounts. So they'll say, yeah, well, my daughter's here. She lives here. So I'm going to put her on my bank account. She'll have access to the money. She won't have to mess with the power of attorney. And it'll just be easier. It'll be convenient. And yes, it's easier. And yes, it's convenient. But if my will says when I die, I want everything to go equally to my children, and I have a bank account with my daughter's name on it, which maybe has $200,000, maybe. When I die, that money becomes my daughter's. Now, she can share it with her brother, or she can also say, I'm not giving him a penny. Mom liked me best and she wanted me to have it, and sorry. So you want to make sure you're not creating that situation with your children, because that's creating an issue after the fact. Most people say my daughter would never do that. She would give her brother the money, and we all hope that she would, but I've seen it situations where that hasn't happened. The other problem with that is now she's got to make a gift of $100,000 to her brother, and now file a gift tax return and hassle all that. So you just don't, you want to think these things through. If it's really important to have that joint account so that maybe they can pay for a funeral or have some money before they're appointed as executor, then okay, create that account, but don't have $200,000 in there, have $20,000, something like that. So things to think about: assets with beneficiary designations pass directly to the designated beneficiary. Outside of your will, we still have to account for it on the Connecticut estate tax return when you die, and you will pay a probate fee based on all of your assets, but you don't want things passing to people that shouldn't get them directly. Or I've even had clients say, I'm just going to give everything to my oldest and they'll take care of everybody. Well, that's a terrible idea, just a terrible idea, because you're putting the oldest in a terrible spot, and it's just not the best way to handle things. So creating a will is really important. Knowing how you hold your assets and where they're going to go is important. So we make sure that your will and your asset structure is matching so that it works. Any questions so far? Yes.
Now, just to get my mind right now, see, we don't have a will. So if we both kick the bucket, you don't get to say that.
Sure.
Oh, good, but, my mom is still 92, 91 years old. So we kick, and she can, so $100,000,
Well, do you have children?
then no kids.
No kids. So married, no kids.
Okay, so we kick the bucket. What happens to the estate if we didn't have a will? You said 100,000 or?
Well, Mary, I said if your parents are alive and you have children, so no kids,
Mom's still.
no spouse, your mom gets it.
Okay. Oh, she gets everything. Oh,
But if your mom's not here, then they're looking to your brothers, your sisters, your nieces, your nephews, we go out. And a lot of people don't want that. Yes.
okay, so we want a will real fast.
All right. Well, there's this little green card that you could say, I want to see Linda. Yes.
What you said necessarily true. So his mother is alive. Let's say he dies before she does. So presumably, depending on how things are titled, everything may go to her.
It may.
And then if they have no children and then she dies a week later, everything goes to her nieces and nephews.
It may.
And his mother gets nothing. I
Correct.
think that's your point about why you have to talk through these things.
Correct. You're right.
So I'm not convinced that his mother would get everything.
Well,
in this case.
again, if they could determine who died first. I mean, if she's alive for, we usually want a survival rate of 30 days, but if there's nothing built in, yes, first it would go to her if she's still alive, and then she dies and it goes to her family. So you're right, and vice versa.
Okay, so if I go first, mom gets.
So if,
she gets-
well, if you go first and your mom's alive and your spouse is alive, and you have assets in your name alone,
Both their names, everything.
well, both your names, it's gonna go to her. But some people have, if you had the house in your name and a bank account in your name, then the first 100 goes to your spouse, anything over and above assets in your name alone. 25% would go to your mom, 75% would go to your spouse. So even though that might not happen, because you own everything jointly, if you got killed by a drunk driver and there was a lawsuit and $1 million is going to pay out, that's how it would go. So it's just really important to have a will in place.
Linda,
Yes.
may I interrupt, please? We're still not seeing any of the slides. It's on the introductory slide, Senior Voices.
Well, they're, I can't think of the word. They're moving here and we see them here.
Oh, they are?
Yeah,
Okay, well,
I don't.
all right, well, that's good. At least we can hear you.
She's not seeing the slides. She's still seeing the introductory slides. So the slides are progressing here in person. I don't know why that you wouldn't be seeing that.
It will be emailed to her after this. I think the library emails the slides.
Okay.
to everybody who has signed up.
I'm not sure if you heard that, but the slides will be emailed to you afterwards.
Okay, thank you.
But the slides are really just talking points for me to remember, you know, so they're not all that
Okay.
informative anyway, but yes,
Right.
you will get a
Great.
copy of the slides.
Thank you.
Sure. So then the question becomes, is a basic estate plan enough with a power of attorney, a healthcare, and a will? Or should we be talking about living trusts or any other kind of trusts, irrevocable trusts or living trusts? So I have clients come in all the time that say, I need a trust. And after we talk it through, yeah, maybe they really don't need a trust. So a living trust is a different way for you to manage your assets while you're alive, and that's the document that distributes your assets when you pass away. Living trusts have no asset protection built in. So it's just a different way for you to manage your money. And people do living trusts for a variety of reasons. If you have property in multiple states, you might want to have a living trust so we're not probating here in Connecticut and in another state. If you have a child that you're going to disinherit, you might want to have a living trust so that there's no probate court proceeding and an automatic forum for that child to challenge in the probate court. They still could challenge, but they'd have to hire a lawyer and start an action in the superior court. Other reasons to have a living trust. Some people want it for ease of, to make things easier to take over the management of assets. The successor trustee can step right in and manage those assets in case you become incompetent. So a living trust isn't necessarily for everyone. If you have those instances that I talked about where you're creating a sub-trust for child, a disabled child, a special needs child, a spouse, a disclaimer trust where you're disclaiming some money, or credit shelter trust where we're trying to use your exemption, then you want a living trust because those sub-trusts are spun off after your trust is settled and there's no probate court oversight. So if you do the same sort of sub-trust in the body of a will, the probate court has oversight of those sub-trusts. So for a lot of folks, they don't want that probate court oversight. They want whoever their successor trustee is to have the ability to just manage that trust without having to do the accountings with the probate court. So there are a lot of different reasons why you might want to have a living trust, but does everyone need one? No, not everyone needs one. Sorry, I keep hitting that. So I kind of got ahead of myself, different reasons for creating a trust. We still have privacy on there. the law changed in 2020, and so everyone used to think that if I have a living trust, nobody's going to see how my assets are distributed because it wasn't a document like a will is submitted to the probate court, it becomes a public document. The trust doesn't become a public document, but under the new law, you do have to notify the beneficiaries when you die, they get a copy of your trust. So if I decided to give 10% of my estate to my son and 90% to my daughter, and I think there's no way that he would know that he only got 10%, I'm wrong. He will get a copy of that and he would see the disproportionate amounts that I put in there. Yes.
I understand about probate avoidance. However, is there still going to be a probate fee in Connecticut? And how does that work and why? Because, you know, grew up saying, oh, trust, everything just passes outside and.
So
and-
the question was, if a living trust avoids probate, why is there still a probate fee? And the answer is yes, there is.
It's only in Connecticut?
And it is Connecticut. Every state is different. Here in Connecticut, the probate fees are how we fund our probate courts. That's how we pay for the probate judges and the brick and mortar place where they work and all their assistants. So that's how we fund our probate courts. And the probate fee happens whether you have a will or a trust, and it's based on your gross taxable estate. So that's everything you have when you die. You're supposed to file the Connecticut estate tax return within 6 months of your date of death, and that lists everything: retirement, real property, money in the bank, investment, IRA, 401k, life insurance, car, everything. So the probate fee is based on a graduating scale. It's a small percentage of your gross taxable estate. So, for example, if your estate was $500,000, the probate fee is $1,875. And if it's $1 million, well, it goes up. It's about 0.5%. So it goes up, it goes down, and it's capped out. And I think 20,000 is the cap. But there's no getting around it. Yes.
620 and then 20,000.
Sure. I'm trying to rewind, see what I said. So the probate fee for $500,000 is $1,875. If your gross taxable estate is more than that, it goes up a small percentage. It's about 0.5%. And it's capped out at 20,000. So if you have several million, you're not going to pay more than that in a probate fee. Don't ask me to do math. That's my daughter's job. She's a math teacher. So not everyone needs a living trust, different reasons for having it. But here's one of the most important things is if you have a living trust, your trust should be funded. So what does that mean? Because lots of lawyers will give you this pretty notebook, pretty red notebook. It's big, it's fancy. You just bought yourself a living trust, but you don't know how to use it. You don't know that you're supposed to put anything in it. And when you have a living trust, you have what's called a pour-over will. And the pour-over will simply says, when I die, if there's anything in my name alone that I did not put in my trust when I was alive, then put it in my trust when I die. So if I have a living trust, but I have a house in my name and bank accounts in my name, and I die, the house and the bank accounts are going through probate to get put over in my trust. When if I had just retitled them in my trust when I was alive, I would have avoided that probate process. So a big piece of having a living trust is to make sure it's fully funded. So if we're doing living trusts for clients, we're doing a quitclaim deed and transferring the house from my individual name to my name as trustee of my trust. Retitling, I mean, I can't go to the bank with my clients. I wish I could sometimes and make sure they retitle all their accounts, but I give them instructions. Retitle bank accounts, investment accounts. Retirement never goes into a living trust, so that doesn't get retitled. But we want to make sure you have your beneficiary designations tidied up on that. I always tell clients to check them. They say, don't worry, they're good. I say, check them anyway, because, you know, they think they got it right, and then their spouse dies and oops, I named my mother as the beneficiary. You know, something inevitably happens because they think they did it and maybe they forgot that they didn't update it when certain things happen. So very important to check and double check on those things. Yes.
What if you only want to put your house in the trust? Is there any reason to do that? I mean, originally, I thought putting my condo in a trust would avoid probate, but it's still to your point. And thank you for sharing that. It doesn't avoid the probate fee.
It doesn't avoid the probate fee. So the question was, is there any point in putting anything other than the house in? Well, if you have a house and an account with $200,000 and you only put your house in the trust, then we have to probate that $200,000 bank account to get it over into the trust, because the trust is what's going to say divided equally among my kids or whatever it
So-
says.
That's taking the place of the will.
Well,
Or you
It-
have both.
you still have both. You have the pour over will, just in case there are assets that we need to get into the trust. But if you've fully funded your trust, and you've done it properly, then the will is really just a safety net. We didn't need to use, we file it with the probate court, not for probate. We file the Connecticut tax return, you pay the probate fee, we settle your trust, you're done. Yes.
How do you get an asset into the trust?
So-
What's the process?
So the question is, how do you get an asset into the trust? So if it's real property, you do it via a quitclaim deed, and lawyers can do that for you. If it's a bank account, then you need to go to the bank. And if it was my trust, instead of my bank account being in the name of Lynda Arnold, I would have them retitle it Lynda Arnold, trustee of Lynda Arnold's Living Trust, dated blah, blah, blah. Now it's in the trust. So you have to go to the banks or financial institutions and ask them to do that. And they may want to see the entire trust document. They may be okay with just seeing a certificate of trust, which outlines the salient provisions. Every financial institution has its own rules, so you sort of have to follow their rules or try to fight with them, and good luck with that.
And automobile, how do you do that?
Well, cars, I don't generally have people put cars in a living trust, but on your cars, and this happens all the time, everything is perfect. You've fully funded your trust, and oops, there's a car, and it's the one thing we have to deal with in the probate court. And even for married couples. My husband went to the dealership, he bought his car, I bought my car, now my car's in my name, his is in his name. If something happens to him, I don't have access to that car. I have to get through the probate process to transfer it to myself or re-register it or sell it or whatever I want to do. So cars catch people. If you have a car in your name alone, on the back of your registration, there's a spot to designate a beneficiary. So pull out your registration, look at the back, there's a spot to put a beneficiary. Someone has to witness your signature. It shouldn't be the same person you're designating as the beneficiary. And then that person needs to know that they've got to get to DMV within 60 days of your date of death to get it re-registered and insured and transferred over.
So does that in the notary? Or is it-
No, it does not have to be notarized. And I just want to touch on irrevocable trusts. And I also was supposed to say at the beginning, when we're done, this little green card, if you want to fill it out, just tell me if you wished you heard different things than I talked about, if your questions were answered, if I could have done a better job, how so. There's a spot to check if you want to get on our mailing list. Our firm does email blasts often. changes in the law to watch for and just interesting things. Some people think it's too much. You can always unsubscribe. But I wanted to touch on irrevocable trust because a lot of times clients come in and say, I want to give my house to my kids. I want to get it out of my name. I want to make sure that nursing home doesn't take it. So I have a lot to say about that. First of all, the nursing home doesn't take your home. The state of Connecticut expects you to use your resources to pay for your care, and your home is one of those resources. Just giving your house to your children is not the best idea because now your house is subject to all the risks that your children have in life. If they have a catastrophic accident, illness, creditor problems, divorce problems, your house is subject to all those risks. And there's the 5-year look back period. So anything you've given away in the preceding 5 years, if you need long-term care and we apply for Medicaid, it could be a problem. The other problem is that you're giving that house to your kids at your basis, your cost basis. So if I bought my house for $100,000 and now it's worth $400,000 and I give it to my kids, I'm giving it to them at the $100,000 basis. And later on when they sell it, they're going to pay capital gains tax. So for all those reasons, not the best way to try to protect your assets, but for people who own a home, it's one of their biggest assets. They're concerned about the cost of long-term care. They don't have long-term care insurance. Then creating an irrevocable trust might be the right tool if you're comfortable with it. You put your house in an irrevocable trust. You name someone as the trustee and they lease it back to you for your lifetime. That lease is recorded on the land records, so you're protected. So if I create an irrevocable trust and have my kids as trustees and my kids as beneficiaries, they lease it back to me for my lifetime. That lease is recorded on the land records, so they can never sell it out from under me. Not that they would, of course, because they're my kids. But seriously, that is some protection that's built in for me. The only control I keep is that I can change the trustees or the beneficiaries. So if someday down the road I say to my kids, hey, let's sell this house, downsize, buy me a smaller one-story condo, and they say no, then I can fire them from being trustees and put somebody in there that's going to work with me to do what's best for me. But I have given up my home. I gave up control. And you have to be ready to do that. I only do that with people who don't have a mortgage on their house because we don't want to put a house in an irrevocable trust that has a mortgage. That's a problem. And then there's the 5-year look back. So as long as I don't need care in the next 5 years, or I can pay for that care, through that time period, then I've preserved that asset. And if I do need a nursing home, the house is not an asset that the state is going to look at and expect me to use to pay for my care. So for some clients, that's a really wonderful thing. For others, lack of control and all the things that go along with it are too uncomfortable. And maybe their goal isn't asset preservation. There are downsides to that kind of planning. Aside from the loss of control, you can never get a home equity line of credit, pull any equity out of your home, get a reverse mortgage. If you were getting a senior citizen discount on your taxes because your income were low, you're going to lose that. So there is a downside.
But what if you designate in the new title that it's for your life use?
Well, that's different. I mean, it gives you, this trust gives you by way of a lifetime lease, life use.
Okay, because it's the revenue.
Correct.
Okay.
But if you just change your deed and I give my house to my kids by way of deed, but I retain a life use, still some problems there, still subject to their risks. Life use has a value to me if I need Medicaid. So there's still some things to think through in that regard. And I talked about funding, the trust. Yes.
Question what you just mentioned. Let's take about the situation, and the individual large and small for $200,000, worth $1 million today, an $800,000 gain. The first question is, and the same question to both your scenarios, a revocable trust, which you call a living trust, or an irrevocable trust. Person A puts that house in a living trust, or revocable trust. I think what you said is that means that that property is subject to the probate fee 0.5% in Connecticut.
Correct.
And an irrevocable trust, is it also subject to the probate fee?
It sure is.
It is. All right. The second question is, how about the step up in basis on date of death? In an irrevocable trust or a living trust, I think it is subject to the step up in basis.
Correct.
That is, the people who inherited, take it at a $1 million value as opposed to 200,000.
Correct.
Is that the same case in an irrevocable?
It is.
Okay.
It is. Yes.
Question on the first. My son this year on May 15th, my mother passed. My brother was in charge of everything. He didn't think it important to tell me she died, but she died on February 1st. And he moved her out from New York City to Long Island. Power of attorney, changed the will, everything like a bank account, whatever. How do I go about finding out what's in that?
Well, as an heir, you should have gotten notice. Oh, sorry, repeat the question. It's a long question if I can. So the question was, or fact pattern, mother dies, but this woman's brother had moved her out to Long Island, changed bank accounts, put his name on everything, won't communicate with her, and now the mother's dead and she doesn't know what was in the will. And quite frankly, you know, if he's already transferred everything while she was alive, if he made all those accounts joint, then joint accounts pass to the joint owner. It wouldn't matter what her will said because nothing's passing under the will. So, you know, if there were things passing through probate under her will, you as an heir should get a copy of that will. But if you didn't, my guess would be that he manufactured it so that he would just get all the money.
I don't think I'm gonna take any, which, is that the kind of litigation your firm handles?
It is, but not in Long Island.
That's a different country.
Yeah. So, and the last thought I'd like to leave you with is just, you know, use the right lawyer. It doesn't have to be our firm. But don't go to Joe Smith, your real estate lawyer, who's the best guy in the world, who does a little of this and a little of that, and might do things in a vacuum that really create a bigger problem than helps. You want to make sure you use a lawyer who does this kind of work all the time, and they're familiar with Medicaid and the ins and outs and gifting and issues, because you want to make sure your whole global picture is in order. Thank you. Thanks, guys. Don't forget your little green card. One more question?
No, it's basically a comment.
Oh, yeah.
If you don't know this already, I was deaf. You have grown children, that you need to let them know where everything is. Because my brother and I ran into a situation where my parents were born early in age. We both got remarried. My father passed away, and my brother and I got nothing. We found out later that they had, my father and his second wife, had an irrevocable trust set up. And she found a lawyer that she was friends with that changed it. So we had to take, and then she passed away, and everything went to her daughter from a previous marriage. We had to take her to court. Yes, half of what was supposed to go off.
It happens with blended families sometimes. And the comment was, you know, to make sure you know what your parents have, but you know, some parents don't want to be transparent and don't feel like sharing that information, and that's the other side of that. But I would certainly,
Stand by.
Yeah, it happens.
running into those things after they pass away, you're gonna be scrambling.
For sure, for sure. Yes,
What fees for these services? A fixed fee, or is it based on the value of these?
so are you talking about administering an estate after the fact or doing these? We do everything on a flat fee schedule. So we charge a consultation fee of $475, but if you have your little, if you say you were here, you get $100 off. The consult fee is rolled into the flat fee if you move forward with documents. So we do everything on a flat fee schedule based on the complexity and your needs, you know. It's not based on what you have, it's based on the documents that we're creating. Thank you. Yes.
Regarding people's insurance. I've heard a little bit about the thing about who they name, especially if they are going to be a beneficiary of the contract. Myself, because you want to make sure that your health representative has my interest, not their interest, so that they're gonna make decisions maybe to inherit my money quicker than, you know.
I mean, yes, I guess you would take that into consideration, but you know,
It's crazy to about that.
it is crazy, but you know, the people that you're choosing to be in those roles presumably are people you love and trust. And you do think that they have your best interest at heart. So I would be very comfortable naming my daughter or my son and knowing that they're not going to pull the plug just because they want my money, but not every family can say that. So it is maybe something for sure to think about. Yes.
So, if you live in Connecticut, and I'm assuming most of you do, and you're having this conversation with someone in New York, there's a difference.
There's a big difference. There's a big difference.
If you don't have what's called a probate asset, you don't go to the probate court at all.
Right. And it's the surrogates court in New York. Mhm.
These are not probate assets. And the top probate fee in New York is only $1,250. And it takes longer to probate. Excuse me? Takes longer to probate.
I'm licensed in New York, but having never practiced, I cannot comment. But there is a big difference between all of the states, so you want to know where you are. And I have these handy dandy little goodies in the on the back table. Very excited about these. Oh, if they can work, yes, little flashlights.
Put it in your car.
So you can have it in your car, and they're on the back table if you'd like one. But thank you for coming, everyone. Thank you for having me. I really appreciate it.
It's good. I always have questions. That's why I.
Oh, that's good.
Okay, thank you.
Hi, everyone. We're not finished yet. We've got more knowledge to give. Okay, so what we have until 2:30, and right now the segment is called the sounding board, and what that means is what I referenced earlier. What's on your mind? So we want to hear from you. This is how we additionally gather the needs of our fellow seniors. So we want to know basically, and I'm just going to say it. I don't know. Sorry. That's okay. We want to hear from you as to what is the town doing right? What needs fixing? What are strengths that we can build upon? And what are weaknesses that we need to shore up? So basically, what's on your mind? And if anyone has questions, we are taking copious notes because we want to address your needs. That is the whole point of the Commission on Aging. So Ingrid, are you raising your hand?
Yeah.
Hi, what's on your mind? Seriously.
Really good crosswalks put up, since they got money, you know, but we need them at all crosswalks. The traffic goes right through them when you're in the crosswalk by like the hair place, hold on. Right by Starbucks there, they fly through that crosswalk. I've been in that crosswalk
Mm-hmm.
in a garden cart and have had
Right.
cars flying in front of me while I'm in that crosswalk. And I've seen people, because I used to water all the flowers here,
Mm-hmm.
and I've seen people in that crosswalk
and cars are flying through them. So nobody's stopping for crosswalks
Even in the new one.
that aren't well marked
Yeah.
or even in the new ones. And there should be cameras on each one, and the town could get lots of money for signs.
Okay, and cameras. Oh, no, that's good.
Yeah.
And I am writing it down. This lady, I saw, okay. Yes, please.
I was coming home at that song,
Mm-hmm.
and somebody was waiting on the power line. And there was a woman standing there buying traffic, and she would go like this to me, and she's going away from me and put it on cross. So I waited, then she went like this to me. I go on the single lane road there, and on a curve, and she's doing this to somebody coming, and I realize someone is coming. Stop.
Oh,
Can't they have those signs that say stop? Go, rather than someone saying, I don't know who handles that, whether it's a state.
and you're talking specifically, okay.
I was just totally.
So this is specifically, or in addition to it, an instance where there might be the power company working on a situation, wherever there's maybe a person that is directing traffic.
Problem because they're working on our line, so I'm gonna write somebody a letter. But they need a sign in their hand, not just hand motion.
Oh, right. Yeah, that makes sense because, yeah,
I don't think they're very expensive.
okay. No, I got you. Yeah, the signs. Okay, sir. Thank you.
How can we improve that new path that's along Lidgy Way or whatever it's called?
I got
The most obnoxious looking.
Are you talking about cosmetic
Yeah.
appearances? Okay,
I have to say, I'm with you.
some bird walk.
I'm with you. I think it's an eyesore.
okay.
It's unsafe. Yeah, absolutely.
And curb appeal is number one with all real estate, whether it's your house or your town.
Yeah, there's so much distraction when you drive.
Okay.
And you have people walking.
Okay,
And at least right now, it's a walkway to nowhere. Yeah. Look at this one.
Pragmatic,
Wow.
has no native species.
okay, thank you. Sir, in the front row?
Yeah, I didn't say, but I heard this.
Sure.
on New Street,
Okay.
We have a four-way stop there,
Mm-hmm.
and it's shocking how many people will go through that at 40 miles an hour. Seems like obviously it can be corrected with more police presence, but also a big four-way stop.
Okay,
Would probably make a difference.
good point. Good point.
Where is he talking about?
New Street, the four-way stand, what is the cross street and Pound? Oh, I always stop. Okay, all right.
You're like 1 out of 5 right now.
Okay, no, seriously, because if you, and that means a full stop because people are gonna, you don't want to be caught doing the wrong thing. Is there anyone else that has something on their mind that we could address, put down on comment? Yes, please.
What's amazing at that intersection is that nobody has died there.
Oh.
It's amazing.
Because
I'm not
they're,
sure about that.
Well,
And I'm not, I wouldn't kid
get
about
your will in
that.
place first, okay? Linda's still here, okay?
Injured maybe, yeah, and there's a blind child.
Oh, okay,
Maybe.
maybe. Okay. Anybody else have any concerns, comments, questions? And I can go into the last topic, which is, change please. This is, pardon me, next month's Senior Voices at the Library. So next month, I know it's up there, but I like to make sure people hear it. Don't miss Richfield's Housing Authority Senior Leadership, Wade Rockwell and Renee Dobos on January 9th at 1 p.m., same place. So Ridgefield Housing Authority has been an important and essential part of the fabric of Ridgefield for over 50 years. Simply put, its mission is to develop and manage public housing facilities for seniors in Ridgefield, and I think our numbers forever growing. So what you're going to be able to learn about is what options are available in Ridgefield and at what cost. What's the process to get on the list and how long is the wait? What is on the horizon? So bring your questions and this is our spot. So, Joe, do you have any other questions?
No, the only thing that I want to say, I
Mhm.
know breaking now, is that Linda and Jeannie are at the back if people want to talk to them.
Yes, they'll stay for a little bit because we've had a lot of questions and I'm sure there are more that you may just have thought of now while we're still finishing up. But I want to thank you all for coming, both in-house and on the screen, the Zoom screen. I hope you've learned a lot. I know I have. And thank you.